Thank you. Right, so welcome members to the 22nd meeting in 2012 of the Subordinate Legislation Committee. As always, ask members to turn off any mobile phones, etc. And we have received apologies from John Scott. Agenda item 1 is an instrument subject to approval. No points have been raised by our legal advisors on the Fishing Boats Satellite Tracking Devices Scotland Scheme 2012, SSI 2012-264. Is the committee content with this instrument, please? Yep. We are, thank you. Agenda item 2. Instrument subject to affirmative procedure. No points have been raised by the legal advisors on the Glasgow Commonwealth Games Act 2008, ticket touting offence, exceptions for use of internet, etc., Scotland Regulations 2012 draft, nor on the Rent Scotland Act 1984 Premiums Regulations 2012 draft. Does the committee have any comments on those, please? Steve.
Thank you, just on the Glasgow Commonwealth Games Act 2008 draft, it's part of what's been provided to us. There's a sentence saying that the touting offence applies to acts done in or out with Scotland. I'm unsure as to what jurisdiction this Parliament has to deal with this out with Scotland, and I'm seeking some clarification, please.
Invite our legal advisors to give us a view.
Thank you, Convener. Yes, the provision for application out with Scotland doesn't actually relate to the regulations which the committee is considering. Section 17(5) of the Act itself, the Glasgow Commonwealth Games Act 2008, specifically provides that the ban on ticket touting applies to acts done in or out with Scotland. That applies as a matter of Scots law proceedings in the Scottish courts, as a matter of jurisdiction. But the effect of that provision is that, for example, when we look at Regulation 3 of the regulations which the committee is considering, that regulation relates to acts of information society service providers established in an EEA state. That provision does extend, because of section 17(5) of the Act, to acts done in the EEA state, but only as a matter of Scots law and in relation to Scots proceedings.
That then, I know it's a different jurisdiction, but in terms of when the Commonwealth Games took place in Manchester and also the Olympic Games this year, was a similar type of drafting or piece of legislation put in place to protect these two events from ticket touting out with the borders of the UK as well.
I'm not immediately, in relation to the Olympic Games, I'm not immediately in a position to confirm that. I would presume that there may be ticket touting provisions in the Olympics Act, but that is obviously a comparison with the Glasgow Commonwealth Games Act, so I wouldn't be able to confirm that today.
So, but what you're saying is, I mean, it's a standard procedure under Scots law to have this type of point raised in terms of the ticket touting. Is that what I'm hearing from yourself?
Its express provision has been made in the Glasgow Commonwealth Games Act for application out with Scotland.
Okay.
Yes.
Okay. Thank you.
So the issue is one that's in the original Act rather than the regulations before us now.
Yes.
Thank you. Do members have any other questions? Right. Is the committee therefore content with those two instruments, please? Yes. Okay. Which brings us to agenda item 3, instruments subject to negative procedure. The Housing Scotland Act 2001, Assistance to Registered Social Landlords and Other Persons, Grants Amendment Regulations 2012, SSI 2012-258. Drafting of this order appears to be defective in that Schedule 2 inserts a new Schedule 5 into the Housing Scotland Act 2001, Assistance to Registered Social Landlords and Other Persons, Grants Regulations 2004. Paragraph 4 of the new Schedule 5 purports to make provision as to the procedure which local authorities must follow in considering applications for Innovation and Investment Fund grants. It does so by requiring local authorities to ensure procedures for A, the invitation of applications, B, the assessment of applications, and C, the approval of grants being carried out in accordance with the terms of a specified external document. On consideration of that document, it does not appear that it contains any provision which regulates the procedure to be followed by local authorities in considering applications for IIF grants. The document rather concerns itself with how Scottish ministers and COSLA will deal with applications for IIF grants from local authorities themselves. The lack of specification as to how a document for a different purpose is to be given effect in these circumstances casts doubt as to whether the instrument effectively makes any provision as to the procedure to be followed by local authorities, despite that being its apparent intention. Do members have any comments on this issue? Mike?
I think that the committee, in fairly strong terms, should ask for this issue to be clarified, not least because very often these projects are funded partially by private borrowing, and we all know the banks are tightening their lending criteria, but they're also tightening their due diligence, and I would welcome, under those circumstances, the need for much greater clarity.
Thank you, Chair. Yeah, I think I'm going to echo those sentiments. I'm also interested in more clarity in terms of sometimes owners, particularly in a close where it's a shared property, where there are clerks of works used or, in fact, agents used. And I'm just wondering what safeguards are there for those people. Also, I think it'd be interesting to find out, are we still relying on the local authority to act on behalf of these owners, or are the clerks of work or agents going to be acting on behalf of those owners who will be carrying out those works? It's not as clear as I would like it to be.
It's a question which our legal advisors might be able to give me some clues on, please.
If it may be of some assistance to the committee, my understanding of the grants in question, PSR grants, under what will be Schedule 2, is that they seem to be targeted towards primarily providing, but also improving, repairing and adapting subjects to provide housing which is for sale for owner occupation. I'm not entirely sure whether these grants would necessarily be apt to cover the situation which committee members appear to have in mind. I agree it's not entirely clear, though, exactly how these grants will operate, but it strikes me that perhaps they may be aimed at a slightly different target, is my understanding of the matter.
And that perhaps makes the point that if the procedure is not laid down in the way in which we're expecting to find a procedure, then it's difficult to know quite what it might cover.
That's exactly the point I'm trying to make. The clarity is missing. I think we need to be a little bit more focused, if that's at all possible. At the moment, it's not very clear.
So, does the committee agree to draw the instrument to the attention of the Parliament on regretting ground I, as the drafting appears to be defective? I think that's where we as a committee want to take it, and I'm sure the government will feel the need to respond. Secondly, the formal meaning of the instrument could be clearer. Schedule 1 inserts a replacement Schedule 2 into the Housing Scotland Act 2001, Assistance to Registered Social Landlords and Other Persons, Grants Regulations 2004. Paragraph 4G of the replacement Schedule 2 purports to provide procedures to be followed by the local authority in considering applications for partnership support for regeneration fund grants. However, the provision requires that the applicant has or is able to obtain control of the development site. As such, it appears instead to be a criterion for eligibility, and so the meaning of the instrument would be clearer, and the internal form of the regulations being amended more closely respected, had that provision been contained in Part 3 of the schedule, which prescribes the classes of persons eligible to apply for grants of this type, instead of appearing in Part 4 in the guise of a procedural requirement. This would appear to be just one more area of uncertainty and lack of clarity. Well, does the committee therefore also agree to draw the instrument to the attention of the Parliament on reporting ground H, as the formal meaning could be clearer? Sir.
Can I just clarify?
Please do.
Please. Sorry, just as a point of clarification, there may have been some confusion with what I just said most recently, because I think actually the question which was asked was dealing with Schedule 5 IIF grants rather than Schedule 2 PSR grants. So I apologise for that confusion. In these circumstances, IIF grants, which were the subject of the first question the committee was asked to consider, are only open to registered social landlords and their subsidiaries, so it's difficult to see how that sort of grant would ever actually apply to the sort of private development type of situation which appeared to be being contemplated.
So perhaps it's not quite as unclear as we'd thought.
Perhaps no. The issue, I think, was rather with procedure rather than with eligibility, is the suggestion.
I would still maintain that clarity is not as clear, because there are instances where you may have a social landlord, but you also may have private owners within that development. And then how would that affect those people? Would they be at risk in terms of they would have to find the full costs, or would they be allowed to take part in that scheme, which is not clear in the current document?
There's a range of questions there which will be drawn to the attention of the policy committee, apart from anything else. Right. May we move on? Yeah, thank you very much. No points have been raised by our legal advisors on the Plant Health Scotland Amendment Order 2012, SSI 2012-266. Is the committee content with that instrument, please? Yes. Thank you. Agenda item 4, instruments not subject to any parliamentary procedure. No points have been raised by our legal advisors on the Glasgow Commonwealth Games Act 2008, commencement number 3, Order 2012, SSI 2012-261, nor on the food protection emergency prohibitions, radioactivity in sheep, and the export of sheep prohibition revocation, Scotland Order 2012, SSI 2012-263, nor on the Land Registration, etc. Scotland Act 2012, commencement number 1, Order 2012, SSI 2012-265, nor on the Private Rented Housing, Scotland Act 2011, commencement number 4, Order 2012, SSI 2012-267. Is the committee content with these instruments, please? Yes. Thank you. Agenda item 5. Scottish Civil Justice Council and Criminal Legal Assistance Bill. This item of business is consideration of the Scottish Government's response to the committee's Stage 1 report on the bill. Members will have seen the briefing paper and the response from the Scottish Government, in which it responds to the issues raised by the committee. Unless amendments are made to the bill at Stage 2 that affect the delegated powers provisions, the committee will not consider it again. Do members have any comments, please? Are we content to note the response? And if necessary, of course, reconsider the bill after Stage 2? We are, thank you. Agenda item 6 is the Local Government Finance, Unoccupied Properties, etc. Scotland Bill. This item of business is consideration of the delegated powers provisions in this bill after Stage 2. Members will have noted that the Scottish Government has provided a revised delegated powers memorandum and will have seen the briefing paper and draft report. Stage 3 is due to take place on Wednesday the 31st of October. The deadline for lodging amendments is 4:30 this Thursday, 25th of October. Committee may therefore wish to agree its conclusions today. Do members have any comments, please? None? Thank you. On an admirably short draft report. Does the committee welcome the amendments to the delegated powers made by Section 2(2)A and 3? Let me start again. Misreading. Apologies. Does the committee welcome that the amendments to the delegated powers made by Sections 2(2)A and 3 implement the committee's recommendation in its report at Stage 1? That the bill should state a maximum level of permitted council tax increase in relation to unoccupied dwellings, beyond which any level specified in the regulations could not go. We do. Thank you. Do members agree that a report should be produced setting out the committee's conclusions on the bill for publication before the deadline of the Stage 3 amendments on Thursday the 25th? We do. Thank you. I think that is all our business. And therefore, intimate to members that our next meeting will be held next Tuesday, the 30th of October, and I close this meeting. Thank you.